Mōna kai kumihana tēnā koa e tū. Silence, all stand for the commissioners. Tēnā tū tonu ki te tū karakia. Please remain standing for prayer.
Kia ora. Yes, Miss Jane.
Commissioners, our witness for this afternoon is Ms Leonie McInroe, and she is represented by Francis Jawchild QC and Tracy Hu, and counsel assisting Andrew Malloy.
Miss Jawchild? Miss Koo? Yes.
And Ms. Hu.
Yes. Sorry. So before we start, may I call you Leonie, or do you like to be called Lee?
Leonie is fine.
Leonie, thank you. I'm just going to ask you if you'll take the affirmation. Is that all right? Okay. So, Leonie, do you solemnly, sincerely, and truly declare and affirm that the evidence that you will give before this commission will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Yes, Miss Jawchild.
Kia ora, Leonie.
Hello.
Now, your name is Leonie Francis McInroe,
Correct.
and where do you live?
In Auckland.
And what's your occupation?
I'm an anaesthetic technician.
And you're also a mother, aren't you?
Yes, I
How
am.
many children do you have?
I have 4 beautiful children.
And is one sitting in
Yes,
the
my
hearing
son
room
is here.
today?
Yeah.
David, thank you. Leonie, if you could start your evidence at paragraph 1.
Leonie, just before you do, remembering that we've got signers
Yes.
and we have a stenographer, so just try not to go too fast. If you go a little bit too fast, I might just put my hand up.
Yes, please do.
Thank you.
In this affidavit, I set out my experiences in seeking justice and compensation and the government who employed him. The process of seeking justice and compensation was, to me, an additional, ongoing and sustained abuse to what I had suffered in Lake Alice at the hands of Dr. Leakes and hospital management. This time, though, the abuser was the Crown. It took 9 gruelling and fraught years to obtain compensation for my cruel and unlawful treatment by Dr. Leakes. However, even then I never received closure because Dr. Leakes and those who supported him were not held accountable through the criminal justice system. Neither did his profession take any steps that I am aware of to hold him to account for what he did to me and other vulnerable children and the young people unfortunate enough to end up in Lake Alice. I believe he was fully protected by the Crown and his profession. My and other survivors' voices were ignored. When I decided to embark upon the litigation, I had several aims in mind. I wanted justice. For me, that meant a fair and just hearing into what had happened to me and accountability of Dr. Leakes and those in government who allowed him to do what he did to me through the criminal justice system. I assumed he would be prosecuted once it became clear what he had done to me. I also wanted financial compensation for the terrible effect that my years in Lake Alice had had on my life and the impact on my children who had to suffer a mother who was not only debilitated, underconfident, often in trauma, and held a core feeling of worthlessness because of what had happened to her, but also who was then reliving the trauma for another 9 years in the period I was raising them. It was a huge part of their childhood. They were 11, 9, 6 and 1 years old. Am I able to show a photo of my whānau?
Yes, of
Thank
course.
you.
Of course
I'd like
you
you
are.
to see that.
These are your children?
Yes,
Oh,
thank you. They are so much a part of this story. Yeah. I also wanted the system to change so that all vulnerable children from then on were protected from the sorts of things that had happened to me ever happening to them. That vulnerable children needing any care in any capacity in Aotearoa are consistently and without prejudice kept safe, protected from any harm and fully supported with no exceptions. That never again in our history can it be said that the Crown became the abuser, the perpetrator, that re-traumatises the victim in any process of seeking justice. That is extremely important to me. I expected compassion from those hearing my story and to be believed and validated for what I had gone through. I was hoping for closure and that justice would be realised. I expected my story would be treated respectfully, with integrity, sensitivity and care. When I filed my claim, instead of compassion, justice, validation and an apology, I received 9 gruelling years of emotional battering, abuse and bullying from the Crown. Without Philippa and Robert, it would have been impossible for me to withstand.
Can I just pause you there and ask you who Philippa and Robert are?
Philippa Cunningham and Robert Chambers, the late Robert Chambers, were my counsel. They were my advocates in the truest sense. I feel quite emotional about this. Without them, I would have given up. They treated me with kindness and respect and dignity and care the entire process. Who I am today, part of who I am today, is a reflection of how they believed in me, that I can be before you. My children and my children's children will always know their names.
We're at paragraph 8.
There were ongoing, prolonged, intentional delays, obstruction tactics and obstruction strategies, and it felt like the Crown were treating me with the callous indifference and cruelty that Dr. Leeks had. Only worse. It was worse because I expected fairness and justice from the Crown. I expected an objective, considered view of the truth as presented by myself and my evidence. I expected fairness and justice. The irony that over the 9 years, my advocate for justice, the Crown became the perpetrator. Today, 26 years after I lodged my claim and let the powers that be know what Dr. Leeks had done to me, I am still waiting for his accountability and the accountability of those who let him do what he was doing. He has never been brought to justice, nor have the many staff who happily carried out his instructions of abuse, and this is something that angers me and disgusts me deeply. I have no closure while Dr. Leeks is not held to account. I want to see him brought before the criminal courts. To not do so, in my opinion, is the equivalent of deliberate and complete absence of criminal justice, and it shows support of his unlawful, brutal treatment. I see it as staggering negligence and justice. It is irrelevant that Dr. Leeks may now be in his 90s. He has had a free life for over 50 years, not being held to account. Those of us who are subjected to his unlawful, brutal treatment have suffered for the 50 years he has been living freely. We carry this as our life sentence. No matter what, I will always have the stigma, the shame, the trauma, the battle to overcome his abuse, the following abuse from the Crown, and the ongoing impact and lasting consequences being held unlawfully in a mental hospital. That is my reality. I cannot undo that. Our children carry this intergenerational trauma inflicted by Dr. Leeks and his colleagues. He is lucky to have had all those years free to live his life as he's wished. Now it's time for the state to hold him to account. He must be brought back to New Zealand and face his accusers. Only that will bring closure to me. In this affidavit, I also give evidence about the experiences I had to make a claim to ACC and the long delays and battles I had to go through to recognise as having been the victim of a medical misadventure due to medical error resulting from Dr. Leeks' treatments of me.
Now, if you move to paragraph 13, Leonie.
I was adopted at 7 days old by a couple who lived in Waihi. My adopted father died when I was 18 months old, and my adoptive mother died when I was a little less than 4 years. I was then placed in the Methodist Mission Orphanage in Auckland, and after a year I was placed with a foster family in Wanganui. I only learned in adult life that they had never adopted me. They fostered me and were paid well to care for me out of the estate my parents had left. During the years I lived with the foster family, the mother was physically and emotionally cruel to me. For example, I recall that she put my arm through a washing machine wringer. That happened frequently. And put darning needles in my feet when she thought I was asleep to see if I could feel pain. I was constantly petrified of her unpredictable and confusing behaviour. I had experienced it from a very young age. And I struggled to know how to react to her cruelty, so I screamed on the inside and showed little emotion on the outside. I had to do most of the housework daily. I was too small to reach the clothesline, so they built a box for me to stand on so I could do the washing. My cough annoyed her greatly. I did not know until I was an adult that I had had asthma attacks. She would get annoyed with my coughing and make me sleep on the lino floor with the dog in the wash house. I did all evening meal preparation. I was not allowed friends or birthday parties. I was often sent directly to my room if there was no housework to do, or if it was takeaway dinner night, straight after school, and I was not fed. I was not allowed out of my room. I would, however, get up in the middle of the night to look for food, as I was starving. This happened on frequent occasions. I was never made to feel part of that family. I was made to sit alone in the kitchen to eat, while the family sat in the lounge. The doors were closed so they could not see me. I was so afraid of the mother that I never dared complain about anything, even when I had pain inflicted upon me by her, Because I did not react to pain, she decided there was something wrong with me, and I was constantly taken by her to various doctors in the area. I also would run out of class at primary school if I was having a coughing fit, and was frightened to tell the teacher why I kept going to the bathroom. To this day, I cannot sneeze normally because that irritated her. I clearly recall her asking teachers if they thought I was odd. She actively sought out anything that supported her belief that there was something wrong with me. I was completely baffled on how to please her or to be accepted or wanted by her. Among others that the foster mother took me to was a Dr. Leeks, a psychiatrist at Palmerston North Hospital. I was 12 years old. Dr. Leeks' assessment of my foster mother is recorded in a report Dr. Leeks prepared, which is in my Lake Alice notes. Dr. Leeks placed me as an inpatient in the adolescent unit at Lake Alice Hospital from July 1975 until October 1976, and then from December 76 through to February 1977. Under his instruction, I was admitted as a voluntary patient to the Lake Alice Hospital Adolescent Unit. I remained in Lake Alice Hospital for 2 periods totaling 18 months. As I understand, this was longer than any other Lake Alice survivor. In that time, I believed I was diagnosed as having borderline schizophrenia. I believe this was his standard diagnosis for all the children. On the 19th of August 1995, I swore an affidavit for the strikeout hearing. I also made 2 statements for my lawyers. One was in 1992 and was made for my ACC claim. The other is undated and was a response to Dr. Leeks' letter. It would have been prepared around 1993. My statements below are taken entirely from these documents. My recollection of the time I spent in Lake Alice Hospital is that it was a terrible experience. I received so much medication, I found it difficult to function. I have particularly unpleasant memory of receiving electroconvulsive therapy on 3 occasions.
Can I pause you there? Do you want to add to that statement?
The first ECT treatment, which I cover further on, was for being smart, disrespectful, cheeky, giggling, and unlike the standard procedures that we were threatened with frequently and constantly that took place on Tuesdays and Thursdays, this was an afternoon, and Dr. Leeks gave me shock treatment himself in the evening, and I remained conscious until I was unconscious. There was no anaesthetic. There was no muscle relaxant. And I recall that vividly. I was placed in seclusion for long periods of time, which I hated. I resented the system of punishment handed out by staff, including ECT. I was afraid of the other patients, particularly some very disturbed adult patients. I recall feeling afraid and anxious and embarrassed because I thought I was a committed patient. The first ECT treatment, I was required to attend compulsory group therapy sessions. I found them pointless. It was my behaviour at the group therapy session that led to my first treatment of ECT. I recall the occasion. I giggled at something and no doubt made some remark. Dr. Lees was present. He said to me, "If you don't cut it out, you're going to get ECT." I apparently did something else that upset Dr. Leeks. I cannot recall what. He then said, "That's it. You're going to get shock treatment tonight." And I did.
Okay.
ECT was not the only occasion when I was given some form of treatment for being naughty. My impression of my time at Lake Alice was that I was given painful injections for naughty behaviour on many occasions. The number of entries of having been given treatment for being naughty is not, in my view, as many times as I recall. For example, on the 12th of the 11th, 1975, disobedient ran over scoria bed, 50 mg of Largactil.
And this is taken from your medical notes?
These are from my medical notes.
Right. If you go on to paragraph 25.
Largactil is a tranquilizer. Both, and I speak of formaldehyde, are classified as antipsychotic drugs. I recall being given formaldehyde by mouth and by injection. I can only recall being given by mouth once. It tasted so foul that I vomited. It was a threat to give it to us by mouth. In addition to the number of times I was giving formaldehyde, I was threatened with it many times by the nursing staff. And if they did not like my behaviour, I was also threatened with ECT.
Okay, we'll now go to paragraph 28.
Can I just clarify about the behaviour?
Yes.
Is that okay?
Yes.
The naughty behaviour that we were punished with drugs, seclusion and other forms of punishment were things like talking or moving or giggling while the staff were watching Days of Our Lives. We were meant to be not visible, not of any bother. We're up to 28.
Yes. Yes.
There were a number of seclusion rooms in the girls' wing. These were used for patients who were uncontrollable or for punishment. You were locked in for various periods of time, overnight, a day, a few days. The seclusion room, like other forms of punishment, was used as a threat. I refer to an entry in the nursing notes, 15th of the 3rd, 76, had the cheek to ask if she could watch TV, threatened with seclusion room. On one occasion I was put in this closed room for many days, I believe 21, for being with a group of girls escaping and trying to see the boys in their villa. We did not succeed. This was discovered days afterward. I was given an injection every day I was in seclusion. I came out to go to the toilet and bath. There was a bucket to toilet in at other times.
Now, if you'd like to move to paragraph 31, how you came to make a claim to ACC and file proceedings against Dr. Lex and the Crown.
It was a strange coincidence of events that caused me to take a claim to ACC and the courts against Dr. Leeks. I was so damaged from my time at Lake Ellis and earlier childhood with my foster mother that I entered my adult years with a chronic lack of confidence and huge fear of authority. I would never have had the courage or wherewithal to contact anyone and make a complaint about Dr. Leeks, but for the fact that my marriage had broken down and I needed a lawyer to finalise my divorce.
And continue at paragraph 34.
When talking with Philippa about my evidence, I commented to her that I had been in Lake Ellis and I was upset about the ECT and drug treatment, and I believed it had been wrong. With Philippa's advice and support and the support of legal aid, I then took a claim to ACC and later filed proceedings in the High Court against Dr. Leeks personally and the Crown. I would never have had the courage to make any claim against Dr. Leeks if it had not been for the wonderful support, persistence, encouragement I got from Philippa. Later, Philippa instructed Robert Chambers as senior counsel. He too was very supportive and caring of me throughout that process.
Now, at paragraph 35, you talk about taking a claim for medical misadventure and medical error and filing that claim in 30 September 1992.
Yes.
Can you now read from paragraph 36? Well, in 36, you're quoting from your GP who sent a letter in support. Could you read what your GP said about you in 1992?
In August 92, Philippa wrote to my GP, Dr. Philip Rushmer, who had been my GP for 7 years at that time, and asked if he was able to comment on the treatment I underwent whilst an inpatient at Lake Ellis. He replied on the 1st of September 1992. He explained he could not, as he had no knowledge of my condition at the time, but he continued, the only comment I can make is my observations of her during the years that I have cared for her, and can say during this time she struck me as being a straightforward, normal lady. There have been no manifestations of any psychiatric disorder, and she progressed through her pregnancies normally with no evidence of any depression in the months following childbirth. One of the main predisposing factors towards postnatal depression is a previous psychiatric history. The next year, he reviewed my Lake Ellis file notes at my request, and on the 16th of February 1993, he recorded in a "To Whom It May Concern" letter that having reviewed the notes, he was appalled at some of the things that went on involving my time at Lake Ellis, including the giving of strong antipsychotic medications and ECT with no good, sound medical reason. Dr. Rushmer wrote another "To Whom It May Concern" letter on the 15th of November 1994. In that, he said that he had cared for me throughout my pregnancy and there was no evidence of any postnatal depressive disorder, that I had not sought medical help or specific help for myself through my marriage problems, and in particular, I had not needed tranquilizers or antidepressant medication. He said that I had managed my pregnancies excellently and continued. All in all, my comments are to state that Lee is a particularly normal, level-headed woman with no obvious evidence of psychiatric disorder, who has cared for her family very well, and in particular I can find no evidence of any depressive or psychotic illness.
Now, at 39, you say that ACC asked Dr. Leeks some questions.
Yes, they did.
Yes, what were those questions?
They asked who was the second psychiatrist who agreed to provide ECT on December 12, 1975, 13 and 15th of December 1976. They asked whether he received signed approval for my ECT from parents or guardians. They asked whether there were any unexpected effects of ECT therapy. They asked, are there any other relevant facts related to the misadventure claim, for deleterious effects of ECT on the dates mentioned?
And at paragraph 41.
Dr. Leeks also said that the possibility of ECT was discussed and permission received from my parents. He said it was also discussed with the social worker concerned and explained to me who was under 16 years at the time of treatment. I was under 16. Dr. Leeks said I was treated with ECT. He said the medication I initially received was insufficient to control my behaviour, but the dosage was not excessive for a youngster of my age, stating adolescents frequently require adult or even greater doses of medication because of their increased basal metabolic rate. He also said he met me in subsequent years after me being in Lake Ellis Hospital following my marriage. Dr. Leeks invoiced ACC $730 for writing this letter, calling it professional services.
And then at paragraph 48.
Dr. Leeks gives the impression that I only spent evenings in the admission ward and was with other adolescents for the rest of the day. This is untrue. There was a separate villa for adolescent boys. When I first went to Lake Ellis Hospital, there were only 2 other teenage girls and myself. We were housed in a ward with adult patients. Although we had a separate wing, the doors were not closed. The doors were not closed to the wings for the men and women patients. Among the men and women were some very disturbed people, including people who were convicted of crimes such as murder. My impression was that all the adults were suffering from severe mental illness. I recall one woman who I witnessed eat a used sanitary pad. While that is one of the more memorable things that I saw in my time there were many others. When we were not at school or in group therapy sessions, we were housed with these people, those adults. On one occasion, I was hit in an unprovoked assault. Refer my nursing notes, 29th of the 12th, 76. There was very little opportunity for recreation or outings, and I have an overwhelming recollection I'd been bored for most of the time that I was there.
I'd like to go to paragraph 51.
I was unable to tell the staff at Lake Ellis the reason why a placement with a foster family in 1976 broke down. I was for a short time placed with a family in Palmerston North. They were a very nice family. I found adjusting to the outside life very, very difficult. I recall the daughter of the family showing me a Methodist newsletter which had asked for a family to take me in. It described me as having been a patient at Lake Ellis Hospital. I felt that this put a stigma on me and that everyone would know I came from a psychiatric institution. Palmerston North and Wanganui and Lake Ellis is in the middle. So all adolescents had an understanding of what Lake Ellis Hospital was in the communities. I sat school certificate in 3 subjects, which I struggled to do. I felt that my ability to concentrate on work was affected by the drugs I was taking. All in all, I was finding the situation very difficult to adjust to. One day I went on an outing with a girl I'd met at school and her father. Her father attempted to rape me. I was absolutely terrified, but I was unable to tell the foster family who were looking after me. I was very untrusting of any adults, and my experience was that they would not believe me anyway. When I was in the foster home as a young child, in fact, I was only about 9 or 10 years old, and I was playing in the sand dunes next to a house that we were visiting. And 4 teenage boys tried to grab me and assault me. And I was very young and I didn't understand what they were doing, but I was frightened. And they kept saying, "We're going to rape you, we're going to rape you." And I was so afraid, and I got away. And when I got back to the house, I said to the foster mother, "These boys have said that they were going to rape me." I didn't understand what that word meant. And she told me off, she scolded me for lying to get attention. So when in Lake Alice, in the foster home that I was put in, my friend's father tried to rape me again, I could not tell the staff or anyone what had happened, because I would be lying to get attention. So what I did was I threw a wobbly so that I could get away from that house. It alarmed the family, and I'd been taught well in the environment in Lake Alice of how to behave, strangely. I was taken back to Lake Alice. Everyone at Lake Alice was angry with me when I returned. I was told I was too old to go to school, so they put me to work on nursing aid duties with elderly patients. I was paid in cigarettes. This seems such a contrast to being given antipsychotic drugs, formaldehyde, for being caught smoking a few months earlier. I recall the medication I was placed on was increased on my return. I was given shock treatment for punishment for ruining it with the foster family. Dr. Leeks commented on his letter that he got permission from my parents and the social worker before giving me ECT. I say that this is untrue. The only social worker I can recall is Janella James, and I wrote to her and asked her to comment on this. She said that it was never discussed with her. I submitted that letter to the court. Dr. Leeks knew that the foster parents did not have the legal right to give permission. In any event, when I told them I had received ECT, they seemed surprised. He most certainly did not discuss it with me, and I reiterate that it was given as punishment. Dr. Leeks was the person who administered ECT to me on all occasions. Dr. Leeks also said that he had met me after I left Lake Alice. This is untrue. I never saw Dr. Leeks between February 1977 and when I left, and then at the secret mediation I attended in June or July 1998. Up until that time, I'd never owned a passport.
Now we'll just pause you there, and we're now at a stage where ACC have received Dr. Leeks's response, and they have sought you and they have sought some specialist opinions. So the first person that gave an opinion looking at the medical notes was a consultant psychiatrist, Dr. Peter McGeorge. Can you read what he says in italics at paragraph 57?
He says there was no absolute clinical reason justifying my prolonged placement in the hospital. There was no evidence for my long-term treatment with oral and intramuscular antipsychotic medication. There was absolutely no indication for my treatment with ECT.
Now, he made another comment when further information came in, and he also discussed your medication. So would you like to quote what he said to the Commission at paragraph 61?
He said, medication for young people should be based on a dose-weight basis, not their metabolic rate. The medication was appropriate for a diagnosis of schizophrenia, but as Dr. Leeks himself stated, his diagnosis was of borderline schizophrenia. If he came to see me as having a behaviour disorder, the medication and ECT would have been grossly inappropriate.
Thank you. Now we'll move to ACC's expert. They then appointed an expert to review what Dr. McGeorge had said, and that was a Professor Weary, who was also a psychiatrist and a lecturer. At paragraph 66, he completed a report, and what were his conclusions, reading from paragraph 66?
He concluded at page 8 and 9 that there was medical misadventure due to medical error resulting from inaccurate diagnosis, inadequate diagnostic and progress procedures, grossly inadequate documentation by Dr. Leeks of his reasons for treatments, the type of treatments and reasons given for treatments prescribed, ECT, neuroleptics, antipsychotic doses, including formaldehyde, fluvenazine, and seclusion.
Thank you, Leonie. Now, after that, what happened? What did the ACC reviewer eventually decide after looking at all the reports?
They decided that I had claim for medical misadventure.
Mm-hmm. Right, and then the next step was to find out what damage had been done to you.
Correct.
Could you, so you were sent to 3 different specialists, and at paragraph 68, Dr. Fernando reported. She was a psychiatrist, a neuropsychiatrist. Could you quote at paragraph 68 or read what she has said about you?
She said, Lee has clearly suffered adverse psychological, physical, educational and occupational consequences as a result of her experience at Lake Ellis Hospital, where she was misdiagnosed and incorrectly treated with ECT and antipsychotic medication. These adverse consequences have had a dramatic and chronic effect on her life, extending over a period of 20 years. These effects have been fear of having a mental illness, stigma of mental illness and fear of discovery, lack of social and parenting skills, assertiveness and compliance, feelings of anger and violation over the treatment received at Lake Ellis, lack of education and reduced occupational choices, an inaccurate perception of her cognitive abilities.
Thank you. And then you went to a Dr. Louise Armstrong, who was a psychologist. What did she, at paragraph 69, 3 paragraphs of what she says about you?
She says, Leonie appeared to give me an honest and undramatised account of her life history and her memories of being in Lake Ellis Hospital. If we accept that she was there for presumed behavioural reasons, possibly at the instigation of her somewhat neurotic caregiver, and that she was under the treatment of a psychiatrist later proved to be incompetent, and his treatment of Leonie has been judged by Professor Weary to be inappropriate, then her account of 2 years in an institution, being treated with antipsychotic drugs, seclusion, and ECT is quite heartrending.
Thank you. Now, Dr. Wallace also examined you. He was another psychiatrist. What did he conclude?
Dr. Wallace said that I have nerve damage around my eye, and it was probably caused by an incident at Lake Alice. It could have been from the ECT or head injury from a blow to the head.
Can you describe the incident where you had a blow to your head?
I was asleep in a small lounge in Lake Alice, and I woke to a young woman who was on remand in Lake Alice for murdering a baby, smashing my head with a heavy metal-based ashtray.
And you had that ongoing problems since then?
They have recommended that, or advised that I don't have the muscle that is affected in my eye operated on because they may make it worse. So my head is at a permanent tilt to the left to balance my vision.
Thank you, Leonie. If you could read from paragraph 72.
My claim was finally settled after that. I recall Philippa had to doggedly fight for everything, going back again and again, challenging their assessments. From memory, I received 2 lump sums of $10,000 and $4,000 for my damaged eye. I did have regular counselling starting with my marriage breakup, but none of it was through ACC. It was through the normal hospital processes and well before I had even been compensated by ACC.
Can you read paragraph 73?
The process of my claims with ACC set the precedent for what was to simultaneously take place by the Crown. I had no choice but to endure long and frequent delays. I could not go forward with civil proceedings until my claims were complete with ACC. Yet I was met with claim declined responses from ACC from the very beginning in favour of Dr. Leaks's blatant and intentional lies. This became an alarming pattern. I was repeatedly frustrated and overwhelmed at the way ACC treated me and my experience. There was no offer of support during this period from ACC. Today, that angers me deeply. Even though my case was dealt with by the Sensitive Issues Unit of ACC, I felt I had to fight to have my story believed. I was sickened and repulsed at the continued letters, correspondence with the subject heading that you could see through the window of the envelope. Mental nervous shock.
Kia rete mōna kai komihana tēnā ko e tū. Silence or stand for the commissioners. Me noho tātou, please be seated.
Are you ready to start again, Leonie?
Thank you.
Good, thank you. Yes, Ms. Joytime.
We're at paragraph 82 of your witness statement. Would you like to read that?
Shortly thereafter, the Crown and Dr. Leeks applied to the court to strike out my proceedings. I had been forewarned by my lawyers that this might happen, but it was still very upsetting. I had hoped that after they saw what unlawful things had happened to me while I was in the care of the state, they might immediately approach me with an apology and a settlement. I would also add that I thought that they would immediately prosecute Dr. Leeks.
Now, if we move now to paragraph 87, to the strikeout decision.
5 months or so later, on the 2nd of August 1996, the strikeout decision was issued. We had succeeded. The strikeout applications were declined. This was a great relief. It was now close to 2 years since filing, and I was hopeful that things might now move very quickly. However, they did not. There were nearly 2 more years of interminable delays before a mediation was organised. Around this time, I recall my lawyers being approached by a lawyer called Grant Cameron, who advised them he had a large number of Lake Alice survivors he was acting for. He asked if he could use our documents for his claim. We agreed and we gave them to him.
Could we have document 20 on the screen, please? And could we... Thank you. Now, this is a letter, Leonie, from your lawyer, Philippa Cunningham, to the Crown Law Office. Can you just read that first 2 paragraphs? The highlighted paragraphs.
We are aware that Grant Cameron of Cameron and Associates in Christchurch is representing a number of former patients at the Lake Alice Hospital's adolescent unit from the 1970s. We have seen Mr. Cameron's proposal for an inquiry in a letter to the Ministry of Health dated 26th of August 1997. We have an alternative process to suggest, which we believe would be simpler and cheaper. Mr. Cameron has discussed this matter with us and would be happy going along with it.
Yes, and then the next paragraph.
We would agree to either a mediation or arbitration. The decider would need to be someone with a background and experience in the mental health area, or there could even be a panel of 2 with legal and psychiatric expertise.
Okay, so if we pause then, do you remember if the Crown took you up on the offer of a mediation or arbitration with Grant Cameron's people?
No, they did not.
Right. You read on at paragraph 89.
I recall at some time Robert Chambers telling me that whoever the Crown settled with first would determine the level of compensation that everyone got. Robert was trying to progress things as fast as possible so that we were dealt with first. That way we could set the standard high for me, and everyone else would benefit. We thought we would be dealt with first because we had filed a claim well ahead of Grant Cameron.
And paragraph 90.
It was agreed that the parties try to resolve the proceedings by mediation. However, my lawyers told me that the Crown set 2 conditions. I was forbidden to tell anyone that Dr. Leeks was coming into the country. I was forbidden to tell anyone he was going to a mediation with me. I was warned that if this came out, the mediation would be called off.
Could we have document 29, please? And could we look at page 2? So this is a letter from the Crown Law Office. Could we put the title of the letter up? It's from the Crown Law Office to Philippa Cunningham. And could you read the the second page of that letter.
I draw your attention to the fact, I draw to your attention the fact that in mid-May, a person describing himself as representing the Citizens Commission for Human Rights, apparently associated with the Church of Scientology, contacted the Office of the Ministry of Health. He said that the purpose of the call was to advise the minister that Dr. Leakes was coming to New Zealand and to inquire whether the minister was intending to take any action against Dr. Leakes on his return to New Zealand. Both Mr. Knowlesley and myself are of the view that it would not be productive for the proposed mediation to become the subject of publicity, whether focused on Dr. Leakes or otherwise. The mediation can only be held on the basis that the fact, time and place of the mediation will remain confidential to the parties and their legal and medical advisors, and I seek confirmation from yourself, Dr. Chambers and your respective clients that this is agreed.
And did you agree that you would keep it confidential and secret?
I had no choice. Yes, I did.
Paragraph 91. Do you read the first two sentences there?
Philippa was also acting for another adult who had been treated by Dr. Leakes in Lake Ellis. We both attended.
And then paragraph 92.
From memory, the mediation happened either on the day we signed the agreed agreement or shortly after. The mediation took place at the Northern Club. Robert Chambers had arranged the venue. I recall he had to lend the other person a jacket on the day, as they were compulsory for men. He was so kind. The surroundings were neutral and reassuring. Linda Kay was the mediator.
Continue on at paragraph 93.
The mediation itself was a nightmare for me. While I knew we were meeting to attempt to settle the case out of court, I didn't appreciate how taxing it would be on me personally. I had vomiting and diarrhea for 3 days prior. I was experiencing prior and for a period of time after the mediation what I now know to be PTSD. I was alarmed at the overwhelming number of Crown representatives present. I felt just as intimidated and vulnerable as I had experienced in being in Lake Ellis. I was absolutely petrified of being in the same room with Dr. Leakes again. I recall the mediator seated us first. When Dr. Leakes and his lawyer came in, she put Dr. Leakes directly opposite me. I felt incredibly traumatised by this. I wanted to vomit. My lawyers arranged for a change of seats. It was an extremely stressful day for me. I felt emotionally exhausted and battered by the end of it and for days after. But I still had hope that there really was at last going to be justice for me and all other Lake Ellis survivors. I felt our stories were unbeatable and insurmountable. I believed the Crown and the representatives of the Crown present had heard my truth. I believed each one of them would be so compelled by what they had heard, they fully believed it was the truth. There was no denying the intentional, debilitating, ongoing abuse of children and young people at Lake Ellis. I believe that the evidence and facts were so strongly in favour of all survivors that finally Dr. Leakes and the people that put him in power would be exposed, and criminal justice and fair compensation would be realised for us all. How could there not be justice with so much evidence? This is New Zealand. We have a fair and honest justice system. I did not realise after the mediation that I was in for 5 more years of prolonged trauma caused by what I came to learn was the strategic, intentional delay and compensation protection tactics from the Crown, who, the longer it went on, seemed to be fully defending Dr. Leakes. I found the Crown's behaviour appalling and indefensible. I eventually came to believe the Crown behaved in a way described best as trickery.
Now, if you say 98 that no office of settlement came after the mediation, was there an offer of settlement at the mediation?
Yes, I believe there was one of $15,000.
$15,000 was offered to you?
$15,000.
Yeah. And you declined that?
I did.
Okay. So if we continue at paragraph 98, the second sentence.
Nothing happened. There was just silence. It felt like torture again. The Crown is a formidable opponent. As the years went on, I constantly felt as though the plan was to wear me down using multiple tactics and strategies. Long periods of time doing nothing and creating long delays was one such tactic. Eliminating my resources, I had legal aid debt that had to be reapplied for frequently against the Crown's unlimited available funds.
Right. And at paragraph 99, you say that Philippa filed an application to court in the end asking for timetabling directions to have the matter set down for a hearing. Is that right?
That is
Yes.
correct.
Okay. And now, could you read at paragraph 100 where the Crown demanded your diaries?
In August 1997, the Crown demanded that I hand over my personal journals. Their purpose was to ascertain whether my current state of mind, by using my personal diaries, showed any signs of mental illness that would justify the treatment that I'd received in Lake Alice. My journals were mostly my letters to God, containing my deepest and most private thoughts. The Crown lawyers kept them August 1997 until settlement in 2003. To me, the treatment of me through taking and keeping my diaries was an act of total violation towards me by the Crown. After a year, I requested them back. I was continually distressed, thinking of my most private thoughts being out of my control. I requested them back every year after that through Philippa. When they finally came back, the pages were full of yellow post-it notes. To me, these notes represent the visible, physical expression of the abuse and violation and trauma the Crown subjected me to relentlessly year after year.
Now, if I pause you there, could we put up document 71? And Leonie, would you like to show the commissioners your diary?
It has never been explained to me what they were used for.
We won't open your diaries, but we just note the yellow
That's how
post-it
they
notes are the
came
ones
back.
that came back
Correct.
from the Crown.
Correct.
Yes.
And I have no idea. They photocopied the pages. What did they use them for? Where were they kept? Who read them?
And when you saw Dr. Brinded's report, you noted that they hadn't been given to Dr. Brinded, had they?
No, they had not. I would like to know what they were used for.
If you read from paragraph 101,
We'll give them straight back to you. We don't want to hold them for a moment.
Thank you.
More than we have to.
It makes me nauseous to this day thinking about the men and women, the complete strangers over the years with no connection or care about me, who could read my very private, heartfelt words that were never written to be viewed by anyone, uninvited by me, to judge and mock my thoughts and feelings, searching for any scrap of evidence to hold against me. I do not know the number of people who read my diaries. I do not know where they were kept, but I know they were pored over by the post-it notes they left. I cannot look at the contents of my diaries now. I have so much embarrassment and humiliation about them. I have never been able to have a diary or journal since August 1997. I have never written any words since August 1997 without the belief that any or all words may be one day used against me.
paragraph 103.
After the mediation and the ongoing delays, I began to feel angry, abused and betrayed by the Crown with its delays. They had the evidence that showed that Dr. Leitz had been giving me drugs and ECT without justification. I was bewildered and afraid at how people who had been through so much could be treated so badly by the government that was meant to protect them. I repeatedly felt devalued, belittled, ignored, disregarded, humiliated, worthless and disrespected. I believe they would not have treated someone from a good background like that.
Now, you got to December 2000 and you still hadn't heard nothing, but could we put document 43 up? Your lawyer had cause to write to Crown Law in December 2000. That letter's on the screen now. Could you read the two paragraphs of what that says? This is from Philippa to Crown Law.
I read an article in the Sunday Star Times last Sunday, 17th of December 2000, concerning 110 former Lake Ellis patients and the Crown Law Office. The article indicates that the government intends to mediate or arbitrate with these persons with a view to settling their claims. The article quoted statements made by the Office of the Attorney General. In view of the Crown's position, these 110 claimants, could you please advise whether the Attorney General wishes to pursue with Miss McInroe?
Thank you. Now, the next thing that happened to you was in March 2001, and that's at paragraph 105.
Just when I think it couldn't get any worse, on the 20th of March 2001, Philippa advised me that the Crown were going to apply to court for me to be examined by a forensic psychiatrist under S100 of the Judicial Act. She attached a copy of the Crown application. Under it, I was to submit to a medical examination to assess my mental condition on Wednesday, the 18th of April, or Tuesday or Wednesday, the 2nd of May, at the Mason Clinic in Point Chev. The psychiatrist was to be Dr. Phil Brinded.
Now, can I pause you there, Leonie? I have got you a little bit out of order. Could we have document 45 on the screen, which was the Crown's reply to Philippa Cunningham's letter, asking if they were going to, seeing they were settling with Mr. Cameron's clients, were they considering settling with you? And the Crown Counsel wrote back, and it's on the screen now in the second paragraph. Would you like me to read it, or do you?
You can read it.
Okay, so the Crown Counsel said to Philippa, you ask whether the Attorney-General wishes to pursue a settlement with Miss McInroe and each have explored the possibility of a settlement through alternative dispute resolution processes, namely mediation. Regrettably, the mediations did not lead to settlement of your clients' cases. Mr. Cameron's clients have yet to have their claims subject to an ADR process. And was that the settlement where you were offered $15,000?
Yes, it was. Where would you like me to
Can we
continue?
now have, you've talked about the notice. Could we have document 52 on the screen, please? So this is a notice of the defendant's interlocutory application for an order. And then could we have page 2 up, please? So was this the order that required you to submit yourself to a medical examination for the purpose of assessing your mental condition on Tuesday the 24th of April with Dr. Phil Brinded at the Mason Clinic, Point Chevalier, Auckland?
Yes, it was.
And can you describe what you know of the Mason Clinic?
I know that the Mason Clinic housed serious criminals that could not be in prison.
Right, so if you read now from paragraph 105, page 33,
33.
paragraph 106.
The reasons Crown gave me for making the order were that it was necessary to determine the accuracy of my allegations of past and present psychological and emotional conditions, whether my stay in Lake Alice had caused, we're not sure about that part,
I think damage.
whether I was under a disability and could not bring proceedings earlier, and when I might have reasonably discovered all of the causes of action I was filing in the proceedings. I was beyond furious, and I was also overwhelmingly powerless. Why did they not do this when I first filed my claim in court in 1994, or even as late as the strikeout decision in 1996? Even why not after the mediation in 1998, even though at that mediation there was a group representing the Crown. They had met and seen me personally give my account of my time in Lake Alice. I had already been examined by so many medical people through ACC, including multiple psychiatrists. The Crown had access to all of it. There had been unbelievable delays since then, and now they decided they wanted to have me examined again in 2001. Would you like me to continue
Yes,
on?
could you continue at paragraph 108?
I was particularly horrified that I was being ordered to go to the Mason Clinic. I felt them making me meet and be clinically assessed by a forensic psychiatrist at the Mason Clinic was another abusive tactic and strategies to reveal some form of mental illness to justify my treatment in Lake Alice. I knew this was a psychiatric hospital for the criminally insane. I felt traumatised just thinking about going near a psychiatric hospital. I asked Philippa to please change the venue. I recall she and Robert proposed a number of alternative places, including the Northern Club. The Crown rejected them all. It had to be at the Mason Clinic. I believe this was intentional. I felt punished for challenging the Crown. It would have been easy to give up at this stage, and I very nearly felt I could take no more from the Crown. I felt completely powerless. I had no choice. I had no choice. I had no choice. I had no voice yet again. Their refusal to change venues was like another personal violation. Going to the Mason Clinic was extremely traumatic. When I turned up on the day, I was taken through 3 sets of doors, each of which were locked after me. Memories of being back in Lake Alice, the trauma, the anxiety, the fear, the smell, the sounds, the keys and locks, and the powerlessness was overbearing and overwhelming. I brought a woman doctor with me as a support person. She was one who had already assessed me. I can't recall her name. It may have been Louise Armstrong. I recall that upon finally entering the room where I was to be assessed, I was so overwhelmed by the experience of just getting into that room that I said to Dr. Brinded, "If you can only imagine that what I have claimed happened to me in Lake Alice is true for just 1 minute, you will be able to understand my need to walk right out of here, right now, catch my thoughts and composure before I have to return for hours more of a grueling interview." Dr. Brinded agreed. He apologised for the location under the circumstances. I can't read.
Shall I continue? I'll continue
Please.
reading this paragraph. I left to return for the interview 15 minutes later. At the end, Dr. Brinded told me something along the lines that he had been sent to interview me by the Crown to find out if they would win against me. Dr. Brinded said he believed me completely and was sorry it had happened to me. I felt so validated having someone say they believed me and apologised to me again for the location set by the Crown and for the wrong that had happened to me in Lake Alice. I felt his apology was very genuine.
I would like to respectfully ask the commissioners to please read his report. As aside from missing one of my children's names, it's the most accurate account.
Thank
My
you.
story.
Perhaps we could have the number so that we make sure that we do read that. You can just provide it to us later.
Certainly.
Thank you. Yes, we certainly will do that.
Thank you.
And now we're at paragraph 113, where you learn that the Crown has actually settled with Grant Cameron's group.
Yes. There were more long delays after I saw Dr. Brinded when nothing happened. At some time I learned that the Crown already settled with all of Grant Cameron's claimants. I understood those survivors had got between 10 and a few up to 40,000 each. I was appalled. It was a pittance for what they had gone through. It was a total sham. I realised that making me be assessed again and the inexplicable delays were intentional delaying tactics by the Crown to give them more time to settle with Grant Cameron's clients first, so that the settlement bar would be set as low as possible. I was beyond disgusted. I felt truly violated by the Crown.
Now, if we pause there, could we have document 55 on the screen, please? Now, this is a letter from Philippa Cunningham to the Crown Law Office after they discovered after that there had already been a settlement. And at the second paragraph, I'll read this for you. Philippa says the determinator model was set up at the instigation of the plaintiffs, that's you and the other person, to allocate the payment by the Crown among the 1905 plaintiffs. And then in the next paragraph she says, the manner in which the Crown has acted in the litigation with Grant Cameron's clients is in sharp contrast with how it has acted in the cases of Ms McInroe and the other person. And she points out your proceedings were commenced in 1994. Could we have the next page, please? And then at the last paragraph she reads, she says, you mentioned that the mediations did not lead to a settlement of my client's cases. The offers to settle at the mediation were in the vicinity of $15,000 each plaintiff. You know very well that that settlement of the cases with Mr Cameron's clients is more than 4 times that amount. In my view, the fair thing would have been to settle the cases with Miss McInroe and the other person first, before addressing the case of the 95 plaintiffs represented by Grant Cameron. It is clear that the Crown has recognised there is merit in the claims of all these plaintiffs, and to have treated Miss McInroe and the other person differently when they have suffered the most in terms of litigation stress is grossly unfair and frankly beyond my comprehension. I am extremely concerned about the huge difference in the treatment by the Crown of Mr Cameron's clients when compared with Miss McInroe and the other person. And then she goes on to ask him to urgently ask the Solicitor General to meet with Ms Duffy. Now, Ms Duffy had taken over the case from Robert Chambers. Do you know why that was?
He became a High Court judge.
He was made a judge. And she says, I can indicate that if a meeting is not forthcoming and which leads to prompt adoption of a parallel procedure of the Cameron model, there will be a direct approach to the Attorney-General to convey to her the indignation of the different treatment meted out to Ms McInroe. I can advise you that both my clients are outraged at the way they have been treated, particularly by the Crown. Up until now, I have dissuaded either of them from talking to the press, but that advice will change unless this matter is fairly sorted out now. And you recall her sending that letter?
Yes, I do.
Thank you. Now you're at paragraph 114.
It is my absolute belief that making me be assessed at the Mason Clinic was a stalling tactic used by the Crown while finalising a low threshold of compensation with the Grant Cameron Group. It bought the Crown more time. I would like to see the documentation between the Crown and Grant Cameron at this time. In any event, the end result was that settlement effectively reduced the amount of compensation to be paid to all Lake Alice survivors.
Now I'll pause you there and ask for document 61 to be put up on the screen. This is an internal email between Crown Counsel and someone else in the Crown Law Office, and it's recording a phone call that you made. Can you tell Commissioners about that phone call?
I remember being so overwhelmingly angry and frustrated and resentful and powerless towards the Crown. And there is no one to tell about that. Who do you tell? Who do you complain to? And so I rang the Crown Law Office. And stupidly and innocently and naively complained to them about them.
I'll just read this file note of what you're said to have said. You said...
Do you mind if it's a nudge so that we can read it?
Yes, please. So this was a person called Elaine reporting to the Crown lawyer. She phoned to advise that she'd contacted Phil Goff's office today because she's sick of the way her case has been handled by the Crown. She thinks the behaviour of the Crown is completely unacceptable. She stated that this case has been going on for 10 years in which she has seen 3 administrations, 3 Attorney Generals, and she's sick of being bullied by the Crown. And then later on, the highlighted bit says that she observed that the purpose of the call was to advise this office of her intentions to contact the media and the wider public audience they would reach because she is...
Ms. George, could you just slow down a little bit? Remember our signers.
Apologies. She observed that the purpose of the call was to advise this office of her intentions to contact the media and the wider public audience they would reach because she was very angry. And the person called Elaine writes, happy to discuss if you wish, and then brackets, while clearly very angry and hurt, she was very controlled in her speech, not abusive, was articulate and would probably interview extremely well. That's about you that she's talking about, isn't it? Thank you. Now we're at paragraph 115.
A settlement offer finally came through around May 2002. By then, Robert Chambers had been made a High Court judge, and Philippa had to get another barrister to advise me on the settlement. This was Elisa Duffy, QC. Unfortunately, she did not have the long background in the litigation. I still wanted 1.5 million or close to it. That was my original claim. That was the amount carefully
Worked out by Robert Chambers.
Yes. Would you be able to finish that for me while I find why?
You're at paragraph 116.
Oh, yes. There it is. Thank you. Sorry. I remember the shock and outrage of what I was offered. By then, I had been put through a living hell by the Crown with no regard to the ongoing effects on me and my family. Over the 9 long years, with the callous nature of the Crown's treatment of my claim, I had come to realise that the only meaningful compensation for all I and others had endured would be money. They were not capable of anything else. But even after all these years, it was not to be. I had to accept that I was not as worthy in their eyes as Rob Chambers believed. We, as vulnerable mental hospital child patients, treated in the most abhorrent and unlawful, cruel manner, did not deserve full justice according to the Crown. I did not believe that any of those lawyers acting on behalf of the Crown would accept for their own child this pathetic residue of compensation. No psychiatrist would accept this for their child. We were not as worthy as others from privileged backgrounds. I recall being told I was offered more than most, and that Grant Cameron's clients got less. I recall thinking it was this or nothing. I had no chance of seeing Dr. Leeks in court. I did not have the unlimited funds of the Crown to fight this any further. I recall believing that I would not get legal aid to fight on and decline the settlement. I recall believing legal aid would be denied because Grant Cameron's clients had settled for such low amounts. I believed the Crown would easily be able to drag my case out for another 9 years and legal aid would not support that length of time. I understood I wouldn't get a higher settlement offer. I felt completely defeated, hopeless and powerless. The Crown had won. I had fought as long and as hard as I was able. I was honest. I had been abused, but they had won. All their delaying tactics were actually only ever down to how much money they could avoid paying. We settled on or about June 2002. My hope was that Dr. Leeks would be forced by the Crown to contribute to compensation. I do not know if this happened. One condition that I set was that I received an apology for the delays. This was to be met outside the terms of the settlement. I was quite specific because I felt that I had no choice but to accept the settlement. I wanted an apology from Crown Law Office to me for the way they'd treated me.
Can we just pause there and put document 70 up, please? And could we highlight it? I mean, could we enlarge it? Is this the apology you received?
It is.
And do you want to read that out?
It was agreed outside of, this is from Grant Liddell.
Yes.
It was agreed outside the terms of Ms McInroe's settlement agreement with the Crown that I would also write to you to convey to Ms McInroe our sincere apologies and regrets for avoidable delays in progressing her case. Please accept this letter as an expression of such regret. The time taken for some steps was longer than might in other circumstances have been needed. In particular, there was delay in providing discovery. This should not have occurred. Please accept our apologies. We take this opportunity to wish Ms McInroe well now and for the future.
And what was your feeling about that apology, that paragraph 120?
I've kept that apology. I don't understand regrets for avoidable delays. I don't believe that Grant Liddell ever thought this would come to the light of day. I cannot even imagine that he ever thought in front of a Royal Commission inquiry that apology would be shown. I don't know, am I misunderstanding that? It is arrogant in the sense that it's a throwaway token. I had to write this. I don't believe he ever thought someone else other than myself would ever see that. It's appalling.
Did you feel that you had been cared for and your hurt acknowledged?
Not at all. I felt like someone had said to him, "You've got to write that." And he did.
And this was in March 2003, so this was 6 months after you'd signed the 9 months after you'd signed the settlement agreement.
Yes.
So you waited 9 months for this apology.
Yes.
Now, could you read it, paragraph 121?
Sometime later, I also received a letter from the Prime Minister, Helen Clark. It was very short and impersonal, and again, it did not feel like a heartfelt apology. From memory, it said she was really sorry this had happened to me. I no longer have a copy of it, Neither letter was a document I could point to in any way to show that I had been wrongly detained and wrongly treated.
Thank you. Now you were talking about Dr. Leeks avoiding criminal prosecution and the lack of closure for you. Do you want to read paragraph 123?
123, 124, is that?
You can read them both.
After the settlement, I still had little hope that Dr. Leeks and others at Lake Alice who had witnessed what he was doing to us and went along with it would be charged for criminal behaviour. It was beyond me why he had not been prosecuted already. Ever since it became clear from my evidence that he had acted without medical justification. I knew there were police investigations underway, but nothing happened. The months and years went by and he was never brought to justice. I am beyond disgusted about this too. Are we not worthy of that justice? Why did the police inquiry stop and never resume? I gained an impression from early on in the proceedings that the Crown were protecting Dr. Leeks, and I continued with this impression throughout the whole period of my litigation, including the mediation. I continue to believe this today, given the fact he was not ever held accountable in law for what he had done to vulnerable children, and there was plenty of evidence that what he was doing was not acceptable practice at that time.
And now at paragraph 128.
I regret ever taking the settlement. I wish I'd taken the case to a hearing and made Dr. Leeks stand in the witness box and answer for himself in public. The public would have known about what happened that way, and the powers that be would have had to have answered for how Dr. Leeks was allowed to get away with what he was doing. And I would have liked to have made those who administered the drugs and did what they were told to be accountable to. Excuse me. Questions needed to be asked from them. However, I was dependent on legal aid to fund the case, and I still doubt they would have funded me to reject the settlement and continue on with proceedings. As I said, at the time, I felt I had no option but to settle.
Thank you, Leonie. And now we're looking at the impact, the ongoing impact of you from being in Lake Alice and litigating for justice. If we start at paragraph 130.
My Lake Alice experiences never go away. For example, earlier job applications would ask if there had been any mental health issues. It was commonly asked for insurance, medical and life purposes as well. I was incarcerated for more than 18 months in a mental institution. Not 2 weeks, not 2 months. I agonised over whether I lie, and is it even a lie if I say no? Or do I admit and try and explain my story? In the early days of my training as an anaesthetic technician, I was advised that part of our role was to assist the anaesthetist with the twice-weekly ECT lists. We assist with providing safe airways and set up for cases and ensure everything is available to provide a safe anaesthetic during shock treatment for patients. I approached my immediate supervisor and explained why I didn't think I could cope with it and asked to be not placed in those theatres. Apparently, he did not have the authority to make that an ongoing decision. He then went to his boss, who went further up, and soon I had the humiliation of realising the whole management layer at my work knew of my past, but not fully, just that I had received shock treatment. Because Dr. Leakes had not been held to account, there was nothing I could point to say that what happened to me shouldn't have, and it was wrong. Instead, I had to wear the stigma, the shame, the humiliation, and trying to catch the story as others perceived it to be.
And at paragraph 134.
So consequently, whenever it comes up, I have a desperate and compelling need that has never lessened. To tell my story from the beginning, from being adopted at 7 days old, so I can justify or hope to clarify or explain why it was so wrong for me to have been there. I was not mentally ill. Today, after 14 years at the hospital where I work, I believe over 80% of my colleagues know that I received shock treatment and was placed in Lake Alice Hospital as a teenager. I also have trouble in my job with cardioversion. This is where a person's heart is shocked back into sinus rhythm. The whole body jolts and lifts. I have coped with it by avoiding looking at the body as it jolts up. I find my Lake Alice history also interferes with the counselling I need to access from time to time through my work. My role at times involves trauma and witnessing some very harsh events. EAP counselling is provided for staff, and there have been 3 occasions that I have used the service. They've involved death in theatre, a child trauma and personal grief. During these counselling sessions, I have learnt now to actively avoid revealing any information about my time in Lake Alice Hospital. I have found that the counsellors tend to get fixated on the Lake Alice part of my story, as if they're intrigued by having a live one in front of them. It is not that I do not try and put my experiences in the past. I recall a friend made me laugh at the ACC letters with the headings mental nervous shockhead. It helped. But no matter how hard I work at looking and proving that I'm normal, the impact of the years of trauma is never far away. As well as I manage the most wonderfully ordinary life that I now have, no matter that my darling children are smart and brave and incredibly loving, proud and supportive of their mum, and as far as I have come in healing from my history, there are still things that cause me distress.
Now, would you like to read this, or would you like to go to your special part that you have written, an additional one that you have written?
I'll read this.
All right, so we'll start at 138.
Thank you. And I apologise in advance for any repetitiveness. We had such time limitations to prepare, and apologies in advance.
You don't have to apologise, please. Just feel free to read whatever you need to.
Thank you. The impact upon my children. The years of trauma justice stole much from my innocent children. They witnessed and lived through their mother being unbelieved, violated, humiliated, belittled, ignored, manipulated, intimidated, and bullied by the Crown. Often they had a broken-spirited mother. Who used all her strength and hope to fight her fears and to be as present and strong and loving as she could every day of those years. They witnessed their mother in tears. They witnessed their mother overcome the fear and anxiety, the ongoing investigations, evaluations, unfathomable demands and violations of the Crown. They lived with a mother full of guilt and shame for bringing this toxic story into their lives. Earlier, they had lived with a mother with a constant underlying fear that she was mentally ill because of being incarcerated in a mental hospital. No one came afterwards and said, "You were not mentally unwell." No one said that. They lived with a mother who feared she was not capable of succeeding in any career or higher education and only capable of menial employment prospects. I am upset more than anything that they had to endure this in their lives. I am angry at what this trauma has stolen from my life personally and therefore theirs. The intergenerational trauma this has had on my precious family. In preparing this statement for this inquiry, the trauma is yet again a big presence in our lives. This document has been one of the hardest things I have had to do. There have been many, many tears. There has been so much sadness and sorrow, anger and disbelief, revisiting the darkest days of my life. I am, however, grateful for the opportunity to say these things. I am grateful for the existence of the Royal Commission. But I am deeply pained at the agony and difficulty in revisiting my experience to the depths necessary to let the inquiry see the true picture. It has not been easy. There is no undoing the ongoing harm I have suffered at the actions and negligence of the Crown, not protecting me in my childhood and adolescence, and then not treating my grievance with even an atom of dignity and respect. The final part. I would like to say, the Crown has had every opportunity to make right the unlawful and cruel treatment, torture suffered by the children of Lake Alice. It is beyond all doubt that these events took place. It is my opinion that the overall response by the Crown has been an abject failure. The doctors and staff were employed by the Crown, and while in their care, in a Crown-owned hospital run by the Crown, the children were subject to continuous, unlawful and cruel treatment. The Crown should be the custodian that protects and defends all children of Aotearoa. They should be entitled to dignity, compassion and justice, both past and present equally. The Crown Law Office should represent everything that is just, right and fair. It should be the highest example of justice in law in New Zealand. However, for me, in my 9-year journey to seek justice, I was instead faced with relentless, calculated, intentional abuse of power. For me, it has been wholly inadequate, degrading, dehumanising and completely deficient of justice. Unfortunately, and most importantly, completely devoid of mana. On reflection, seeing my litigation process condensed today, I'm overwhelmed. I'm overwhelmed by the obvious and blatant abuse of power. I am overwhelmed at the strategies, tactics and extreme lengths the Crown went to oppress me. I wonder about the enormous monetary value the Crown invested in not settling with me so many years earlier. I wonder what the Crown paid in the 9 years of quote Grant Liddell, avoidable delays. The tactical stalling, the huge financial debt for Crown Law Counsel, mediation costs, the forced examination I had to undergo, on top of all the examinations I had to undergo through ACC, that the Crown paying someone, or many, to read through my personal diaries, my legal aid debt was $49,000. I believe the Crown consciously and deliberately deprived me of justice, using its unlimited financial resources to do so, knowing full well my very limited resources in comparison. I stress this point only because it seems the entire focus of the Crown was to financially defend and protect Dr. Leeks and themselves against my litigation. There was not one point in the entire process the Crown acted with any genuine care or respect to the actual harm I had suffered in Lake Ellis. Not one, not ever. I understand that this Royal Commission of Inquiry is about abuse in state and faith-based care. And while in no way minimising or belittling any other experience, with respect, I would like to highlight the added stigma and shame the children of Lake Ellis endured. Today I refer to them as the children of Lake Ellis, instead of victims or survivors. This is to remind us all that before we became survivors, we were children first. Children that were defenceless and left unprotected in the most horrible ways, and then left to navigate our lives as best we could. I would like to acknowledge all the children from Lake Ellis who have courageously lived through the trauma and the consequences of our time spent there. It is my hope that the outcome of this inquiry is more than just another list of reports and recommendations that are shelved, left gathering dust, and overshadowed by still more reports, that the voices who have so bravely spoken to you, in whatever form, are honoured and respected and valued enough to make change. It is my absolute expectation that these inquiry findings become living documents used in everyday practice of those who are in direct contact with historic, present or future dealings with vulnerable children. Finally, Commissioners, thank you for listening to our voices. I would like to acknowledge the inquiry's commitment to the ongoing care, concern for and well-being of survivors. Everyone has been so kind and so supportive, and I'd like to acknowledge that. Over the past few weeks, it has been said to me by several different people that my giving evidence is leaving a legacy. I struggle with that concept. I would want to leave a legacy that has some elements at least of goodness or change for the better or hope. My story doesn't feel like any of that to me. My choice to not have name suppression and to come forward publicly is excruciatingly difficult for me, if only to protect my children and grandchildren from what happened to me as a child or any distortion of the facts and truth that I speak of in giving my evidence. Commissioners, this is what I would say to my darling children. I am so sorry. I am sorry that this is all a part of your story too. I am deeply sorry that you have also had to endure and suffer the vast consequences of not only the things that happened to your mum as a child, but the ongoing impact on your lives over the years that I sought justice. I am sorry for the emotional price you each have paid, and you have, in so many ways, right up to this very day. I'm so sorry I could not protect you from that. This will forever break my heart. I am aware that my evidence presented today does not fully capture my time in Lake Alice, the abhorrent treatment by the Crown or other trauma I suffered as a child. I realise now that since the day I was born, the documentation, scripting, conversations, opinions, categorising, and invasion of my personal self started and has never left me. I simply cannot comprehend the sheer volume of strangers that have viewed, commented, judged, and invaded my life. It is truly staggering. And here I am again today. Yet again, subject to still more exposure and more trauma, because to not do so, to not speak the truth, is also not an option for me. It has not been easy. And if there is a legacy to be left, Commissioners, I would address it to my beautiful grandchildren. To them, I would say, precious ones, be fearless to speak the truth. Go well beyond any fears of humiliation or your own vulnerabilities. Be fearless to stand up to what is right and just. Be fearless to stand up and speak out for any injustice to any vulnerable soul. No matter the perceptions of others, no matter the challenges or the very size of the obstacles you face in speaking the truth, just speak it anyway. What justice looks like to me. That Dr. Selwyn Leeks is probably, and without further delay, returned to New Zealand to face criminal charges. The evidence for prosecution is enormous and should include staff of Lake Alice who carried out the ongoing daily abuse and torture. They collectively must be held to account. I cannot understand why this has not yet happened. A meaningful public apology for the suffering endured by the children of Lake Alice that fully acknowledges that most of them should never, ever have been placed in a psychiatric hospital and treated as psychiatric patients. A public and heartfelt apology for the injustice, harm, torture and assault suffered by the children using, amongst other things, antipsychotic drugs and ECT as punishment against them, acknowledging that this was so very, very wrong. Acknowledgement that Dr. Leeks made widespread and incorrect diagnosis of schizophrenia, borderline schizophrenia, and other terms of schizophrenia he chose and wrongfully named most of the children there with these labels. That a reparative process is made available without time limitations to any of the children of Lake Alice for their emotional well-being and healing of any trauma, stigma or related issues from abuse suffered as a direct result of their placement in Lake Alice at no cost to them. That the voices bravely spoken are echoed to find and make positive change in the form of a living document. That a review of the settlement payments to date that amount to nothing more than pathetic tokens of disregard and silencing by the Crown. These pitiful payments have no redress for the enormity of the impact on our whole lives and the ongoing intergenerational effect. That reviewed compensation covers the severe treatment endured in our formative years, depriving us of basic human rights at the time. Every right in the Code of Health and Disabilities Act was failed to us in every possible way. This treatment of abuse was not just over a period of days or weeks in a psychiatric hospital, but sustained for many for long periods of time. The reviewed compensation should reflect the harm caused, also taking into account the physical and emotional assault that left us vulnerable and limited our potential of bright futures as children of Aotearoa. It should recognise that after leaving Lake Alice, we were then left to navigate our wounded lives as best we possibly could, with no assistance, no compassion or help, leaving a huge deficit in terms of education, careers, financial stability, emotional stability, and caused limitations to fully participate as valued and contributing citizens of Aotearoa. The review of compensation must surely come forward to view the children of Lake Alice as finally worthy of fair and just compensation that can make a significant difference in each of our lives. That the same measure of redress is used for us as any other valued child. That it reflects the acknowledgement of wrongdoings and further impacting our lives. That it reflects the tremendous ongoing battle to be heard and validated. That it reflects the deficit caused by silencing the abuse of power from the Crown and the tremendous loss suffered. That is all.
Thank you, Ma'am. That's the evidence that you present today.
Thank you very much. Thank you, Leonie. In your evidence, you referred to the pain and difficulty in revisiting your experiences. You've made that evident, and we appreciate, to the extent that we understand the cost that it has been to bring that to us today.
Thank you.
And not just to us, but to the representatives of the Crown Law Office who are sitting here today, and to the public of New Zealand who can be present and can watch this as well. So I want you to know that the pain and the difficulty that you have endured is not gone without notice. I also want to tell you, if you don't know already, that although this hearing focuses on redress and these experiences of survivors in seeking redress for abuse in various settings, next year, and it has already commenced, is a full investigation into Lake Alice, and we will be holding a public hearing on that as well. So this is not the end of the story. So finally, you spoke of a legacy, and I just want you to know that you have a valuable contribution to the work of the Royal Commission, and that your story, your account, will be part of the legacy of this Royal Commission. We thank you for that.
Thank you.
Unless there's anything else to be said. Yes, Mr. Malloy.
I just wonder if we might take a short break, allow Leonie a chance to reflect. I imagine there probably won't be anything else she wants to say.
You think...
But let's take a short break and just see if that's the case.
See if that's the
Give her a
case?
chance to reflect.
All right. Thank you, Mr. Malloy. Well, we'll do that.
Thank you.
And we will return.
Kua heke tēnei noho anga, tēnā ko e tū. The sitting is adjourned or stand.